Hi, good evening. My name is Kelly Mitchell, and today our group will be presenting one of the topic under Chapter 7, Law of Thought, which is trespass. First of all, nowadays everyone wants to preserve their body and property from external intrusion and from another wrongful intention that want to harm and destroy it. So, it is reasonable to develop such a law to protect the individual's property and body. Trespass also can be termed as the wrongful act done directly and intentionally to cause harm to another property. Trespass is both criminal and civil law because it can cause injury, violation of legal rights, as well as damage to one's person and property. In civil law, it deals with the disputes between individuals, organizations, or between the two in which compensation is awarded to the victim. Under tort law, the owner of the property or plaintiff must give proof that the offender guilty in order to recover damages or receive compensatory relief for injury or loss. While in criminal law, it is the body of the law that deals with crime and the legal punishment of criminal offenses. Trespass is held to infringe upon a property owner's legal right to enjoy the benefit of ownership. Criminal charges, which range from violation to felony, may be brought against someone who interferes with another person's property legal rights. So here, there are three types of trespass. First, trespass to person. Second, trespass to good. And another one is trespass to the land. So what is trespass to person? The meaning of trespass to person is a direct or intentional intrusion with person's body or liberty. The acts of trespass to the person are generally crimes as well as torts, and it has three main forms. First is assault, second is battery, and third is false imprisonment.
The first type of trespass to person is assault. An assault is an attempt or a threat to do a corporeal hurt to another, coupled with an apparent present liability and intention to do the act. Penal Code Section 351 has defined the definition of assault. Whoever makes any gesture or any preparation intending or knowing it to be likely that such gesture or preparation will cause any person present to apprehend that he who makes that gesture or preparation is about to use criminal force to that person is said to commit an assault. However, words with no gesture is not an assault. Based on Penal Code Section 351 explanation, it says mere words do not amount to an assault, but the words which a person uses may give to his gestures or preparation such a meaning as may make those gestures or preparation amount to an assault. There are three elements of assault. The first one, there must be a positive act by the defendant. The second one, the plaintiff must have a reasonable apprehension of immediate physical contact. And the third one, the defendant's act of interference must be intentional. An example of assault can be seen in a case. The case is Thomas versus National Union of Mine Workers, 1986. The second type of trespass to person is battery. Battery is the intentional and direct application of physical force to another person. An actual contact is not necessary in an assault, but it is necessary in a battery. Even a slight touch will be counted as battery. So there are three elements of battery. The first one, there must be an act by the defendant. And the second one, there must be an intention to cause harmful or offensive contact on the part of the defendant. And the third one, it must be harmful or offensive contact to the plaintiff. We can see the example of battery based on the case of Wilson versus Pringle. The third form of trespass to person is false imprisonment. False imprisonment means unlawful restraint of someone which affects the person's freedom of movement. The word false means wrongful, and the word imprisonment means restraining a person's liberty to go to any place at any time they will. Based on Article 5, Clause 1 of Federal Constitution, no person shall be deprived of his life or personal liberty save in accordance with law. Both the trait of being physically restrained and actually being physically restrained are false imprisonment. For example, if someone wrongfully prevents someone else from leaving a room, a vehicle, or a building when that person wants to leave, this is an example of false imprisonment. So, an individual must be confined to a substantial degree where their freedom of movement is totally restrained. So a case that has talked about false imprisonment is the case about Bird versus Jones in 1845.
Trespass to goods is the direct and wrongful interference with goods in the possession of another. The interference with the possession of goods may be seizure or removal or by direct acts causing damage to the goods of another party that not the owner, as in the case of land. For example, in this situation, such removing a tire from a car and destroy or damaging the goods of another person. Trespass to goods can relate to the case of Kirk v. Gregory, where a woman who moved jewelry belonging to a man who had just died from one room in his house to another room under a reason but mistaken belief that it is necessary for the safety of the jewelry. Then the jewelry was stolen. In this situation, the woman was held liable for the jewelry defenses. Trespass to goods can be justified if it is done in defense of property or person or in the exercise of the legal side or under legal process. This situation happens when a defendant tries to protect his body or property or any other person's property and harms another person by using reasonable force. For example, Jenny's dog attacked Lisa's cat, and in order to save her cat, Lisa causes harm to Jenny's dog. It is justifiable. There are two types of remedies, which is detenue and damages. The thought of detenue occurs when a person wrongfully detains a person's property and unreasonably refuses to return that property to the rightful owner. Detenue is similar to the thought of conversion except for a specific element. It is a condition of the action of detenue that the plaintiff has made demand for the return of goods, and the demand has been refused. The plaintiff must also have a right to immediate possession of the chattels, while damages is the monetary compensation that must be measured by the value of the goods or the amount of injury done to them. Conversion is the element of trespass to goods, which means a person who treats goods as if they were his and do whatever to the goods when they are not is liable for conversion. The intentional interference with the property of another amount is conversion. There are 5 types of conversion. First, conversion by wrongful disposition of goods. Next, conversion by taking goods. Conversion by detention of goods. Conversion by wrongful destruction. And the last one is conversion by wrongful delivery of goods.
This is the definition of trespass to land: intentionally entering or remaining on or causing any physical matter to come into contact with land in the possession of another. It is an unjustifiable interference with the possession of land. Its function is to protect the possession and not the ownership of a land. This is the 2 elements of trespass to land. The first, we have possession of land, and the second one, we have unjustifiable interference of land. This is the explanation of possession of land. Trespass to land protect a person's possession of land. Only a person who has exclusive possession of land may sue. These are the two types of possession. The first one, de facto possession, having a thing under the physical control of a person to the exclusion of another or an actual possession. Can exclude others not to involve because you are the man to control the land. The second one, de jure possession. Possession in the eyes of law, and the law may presume that a person in its possession of particular property. Maybe you don't have control, but then in the eyes of law, you are the one who possesses the land. Trespass to land is essentially a violation of the right of possession, but not of the right of ownership. In example, a landlord cannot sue for a mere trespass to land in the occupation of his tenant. Such an action can be brought only by the tenant. A tenant even may sue the landlord himself if the latter's entry was not justifiable under the lease agreement. A landlord of leased premises does not have exclusive possession, nor does a lodger or a license. However, a tenant or subtenant does. The explanation of unjustifiable interference of land. First, by wrongful entry. Personal entry by the defendant or by some other person or animal into a land or building posed by a plaintiff. Second one, by remaining on land beyond the permission given. Even a person who has lawfully entered commits a trespass if he remains there after his right of entry has expired. And the third one, by placing things on land. To place any physical object or noxious substance, or to throw stones, or to pile rubbish upon plaintiff's land. The next slide is going to tell you a cases which Hickman vs. Mazie that trespassed to a highway.
In this slide, we're gonna look on interference with airspace. There has three. The first one is with the surface of plaintiff's land. The second one is with the subsoil below the plaintiff's land. And the third one is with airspace above plaintiff's land. This is an example case for trespass to land. Wullerton and Wilson Ltd, U. Richard Constant Ltd, 1970, 1 WLR 411. Let's take a look at this slide. It shows about adverse possession. The meaning of adverse possession is about the occupation of land to which another person has title with the intention of possessing it as one's own. There is principle of English common law under adverse possession. The first one is no defense to an action for ejectment, means cannot defend yourself by arguing adverse possession. Second is, in Malaysia, adverse possession has been abolished by the promulgation of the National Land Code 1965. Third is, under Section 48 of the NLC, there can be no adverse possession against state land. So, we have come to the conclusion of this topic. Trespass can be faced by people in innumerable times in a day, but what is important is to truly understand the nature of Trespass Act, property, laws, and impact of it on the plaintiff. If the nature of the act is itself suggestive of a wrongful incident voluntarily undertaken to constrain the enjoyment of the right to exclude from the private property, then evaluation of all possible resources to recoup the damage should be identified. The fourth test when deciding trespass disputes, court should evaluate the following factors. First, the nature and character of the trespass. Second, the nature of the protected property. Third, the amount of substantiality of the trespass. And fourth, the impact of the trespass on the owner's property interests. It will help to uncover various facets and understand the dimension that trespass law is clutching in its circular surrounding so as to loosen the screws and solve cases and situations in an effective manner. The true meaning of each term needs to be understood to evaluate the trespass and resolve the cases by applying the relevant doctrines. And the last part of this slide is all about supporting document. Thank you, and that's all from us.